Hello, everyone. Thank you so much for joining us today on Immigration and Jobs Talk Show. It's really good to have you. And before I go on with who's going to join us as our guest for today and the topic we're going to discuss, though you can already see probably, our topic of discussion, I have this very important disclaimer. And that is by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. Once again, dearest friends, a very warm welcome to all of you. Thank you for joining us on Immigration and Jobs Talk Show. I'm your host, Nipasa Pradhan, and today we'll be diving into a critical topic that might be affecting your H1B status. So, is your H1B at risk? Well, we will be uncovering some common issues like wage violations, LCA problems, and legalities surrounding who should pay for H1B fees. So, joining us for this discussion today is none other than our guest for today, Attorney Chand Parvathaneni, Managing Attorney at law firm of Sim Parvathaneni and Brown. Chand is an expert in employment-based uh, immigration, and together we'll break down these issues to help you stay compliant and protect your status. So, thank you so much for joining us once again today. Good to have you with us today, Chand.
Hello, Nipasa. Thank you so much, and hopefully we'll have a very productive discussion on various violations that we see about wages. Wage violations are a very important topic in H1B. People have to be very cautious. Employers have to be cautious. Employers have big repercussions if they do not follow the law, and sometimes, unfortunately, we see some employers not complying with the rules, and that
Mhm,
negatively impacts the employees. Even if the employer does not follow the rules and does not pay the employee on time, uh, a
mhm,
lot of times what we see is we see USCIS revoking those H1Bs, and in the end, it's actually impacting the employee. So the employee who has not even done anything wrong sometimes gets impacted, which is why it's a good topic to discuss and see what kind of rights employees have, what kind of obligations and responsibilities employers have, and see what can be done to protect everyone's rights so everybody works within the legal framework of the H1B regulations.
absolutely. And thank you so much, all of you friends, today for joining us. Yes, a special welcome to all our viewers out there tuning in from YouTube, LinkedIn, Facebook. And it's going to be a great one today. Stay tuned because we're going to discuss about this. And please feel free to ask whatever questions you have regarding this topic. Some phases you're going through with your H1B status, feel free to comment them and we'll take them up later in this session we're having today. Thank you once again for joining. So, without further ado, Chand, I think we should go ahead with our show for today. And I got some questions prepared for that. And this first one, what are the legal requirements for employers regarding payment of prevailing wage to H1B employees?
So all the employers who are sponsoring H1B workers, they have to comply with all the requirements as far as the prevailing wages are concerned. And what that means is every employer should do a prevailing wage determination. And the prevailing wage for a particular position, it can be done through various ways. The DOL lets us do use various means. You can use the wage surveys. You can use a few other sources. You can actually reach out to DOL to get the wage. And the most common way people determine the wage is through FLC data center. So there are wages published in FLC data center, and that is the most common source of prevailing wage. And the first thing that the employer has to do is figure out where the employee is working, the job duties, the nature of the job, and so on. There are a few things, and they have to be plugged in to get a prevailing wage. And this is very important. And then, even before filing an H1B petition, the employers must submit an LCA, labor condition application, to DOL. And this application, this labor condition application, it includes details about the job, the wages that are being paid by the employee, and it also has assurances that certain employment conditions will be met and all the required guidelines will be followed by the employer. So they actually have to attest to a few things, and this is a part of the LCA. And the minute the LCA gets signed by the employer, the wage obligations start. And what that means is employers have to pay the H1B workers at least the prevailing wage, or sometimes the actual wage if the actual wage is higher. So whatever actual salary that they're actually paying other employees in a similarly situated job, or the prevailing wage, whichever is higher, the employers have to ensure that the H1B workers are paid and they're not underpaid. The whole point is, if the H1B employers can keep underpaying their employees, that's going to impact the whole US labor market. So these are all these rules in place to ensure that we are not indirectly impacting the labor conditions, the wages of US employees. So this is very important, this whole part of getting the LCA done and so on. And the next big part is the record keeping. Employers are actually supposed to maintain records that do demonstrate compliance with the wage requirements. And what that means is the pay stubs, documentation regarding the job, and so on. One cannot hire somebody in Oklahoma because the salaries in Oklahoma are a lot less compared to what is in the Bay Area in California, and ask the employee to work in Bay Area. So there are rules. So this record keeping is very important. Record keeping about the pay statements, the nature of the work being done, where the employee is actually performing the work, and so on. And the bottom line is, employers must adhere to all the applicable labor rules, regulations, and ensure proper workplace conditions are met. There is no discrimination, and so on. The big thing to know is the penalties. The penalties for non-compliance are very severe, and the employers, and that is the whole reason why the DOL even ensures that LCA has to be done before the H1B can be filed, because they attest to something and they don't comply. There are repercussions, there are penalties, there are back pay requirements, potential disqualification from H1Bs, and so on. So the bottom line is, it is really crucial for the employers to navigate all these requirements and avoid all legal issues, and ensure fair treatment of H1B employees. Make sure the proper wage is being the proper prevailing wage is being given to the H1B employees.
Absolutely. And these wage issues are to be very careful with. Actually, everything, whenever you go through all these, it's everything is legal and it has to be on the point, and proper documentation is required with proper details. So thank you so much, Chan, for covering that and telling us more about wage issues. And let's move on to another question. And that is, how can an employee prove that their employer is paying less than the wage stated in the labor condition application, or the LCA?
Sure. So the primary requirement of the H1B program is the employer should be paying as per the LCA. And if everybody is following the rules, there is no problem. But however, what happens is, sometimes some employers, because they try to take advantage of non-immigrant employees, and they don't pay what they're supposed to. And if an employer is not paying the employees what they're supposed to, it is not only impacting the employee, it is impacting the US also as a whole, because now employer is motivated to hire a non-immigrant employee, which means US employee will not get the job because somebody is able to circumvent the law and pay somebody a less salary. So there is like a ripple effect. So if the employer does not follow the rules, there is a lot that is going to impact the labor market, and so on. And what that means is, every employee should be paid what they're supposed to be paid. And some employers, unfortunately, do not pay their employees what they're supposed to be paid. And the employee can prove that the employer is paying less than the amount in the labor condition application through several methods. And the first and the foremost thing is LCA documentation. The employers do not have a choice. They have to give a copy of the LCA to the employees. If they're not doing it, they're doing something illegal. So the bottom line is, every employee should go back to their employer and demand for the LCA in case it is not given. The employer should voluntarily give that LCA. If they're not giving the copy of the LCA, there is a illegal thing happening right there. But if an employee sees that their employer is not giving the copy of the LCA, immediately demand for the copy of the LCA. The LCA has the promised wage, and that is the starting reference point for an employee to know how much they should be paid, where they're supposed to work, and so on. That is the first and the key thing that everybody should do. And the second thing is pay statements and payroll records. Make sure you collect the pay statements and you keep a copy of your bank statements, your payroll records. These all will show the actual wages paid. And sometimes the actual wages probably are less than the wage because there will be some tax deductions. So make sure you're looking at your pay stubs and seeing what are the taxes being deducted and so on. And the gross salary should definitely match whatever is promised. So make sure only the legitimate taxes are being deducted, and make sure your payroll records are accurate. Sometimes we have seen employers putting a wrong address, and what they do is some states don't have local state income tax, so they put a wrong address. And for example, state of Texas does not have the state income tax, so they some employers try to do these kinds of stuff and put the wrong addresses and so on to not pay the right taxes. So everybody should look at their payroll records, look at their pay stubs, see what taxes are being deducted, look at your bank statements, compare, and make sure the data matches. That is very important. The next big place to look for is your employment contract. Look at what your employment contract says. Typically, everybody will have an employment agreement or an employment offer letter where the wage terms are written. And if your wage is less than the LCA wage, definitely that's going to strengthen up your case. That means the employer is trying to purposely give you a lower wage, and that cannot be done. So definitely look at your employment contract, and that's a good place to see if employer is trying to do something to pay you a lower wage. And then another thing you can do is job comparison. A lot of employers, they try to put a lower wage level. The rule is the wage level has to be appropriate to the nature of the job and similar positions within the company. So if a company is trying to give you a lower wage and choose a lower wage level, they might be doing something illegal and might be underpaying you compared to your peers. So look at similar positions within your same company, compare your job, and document if you feel that you're being paid a lower wage level compared to these other employees in a similar position. Also collect witness statements. Witness statements are also a very important statement because sometimes if a company is a bad company, they don't not only underpay you, they're probably also underpaying other employees in that company. And sometimes it is systematic. Sometimes some companies feel that they can uh, exploit foreign workers. So sometimes they might be doing this to other co-workers also. So try to gather statements from all your co-workers. See if there is a systematic pattern of underpaying your co-workers in your company. If that is the case, document it. Communication records. Sometimes some employers, what they do is they try to ask you to go on forced vacation. They bench you. Benching is illegal. They cannot bench you and not pay you. So sometimes they send you text messages and all these messages and say, hey, don't come to work, and because you're not coming to work, we'll not pay you. Benching is highly illegal. So they cannot underpay you because you're on the bench. So definitely save all the communication records. And then, if you believe that you're being underpaid after doing all this analysis, the first and the foremost thing that everybody should do is look into filing a complaint with DOL. So DOL has their wage and hour division. The wage and hour division, it's called WHD. They typically investigate wage violations. So filing a complaint with DOL with WHD is very easy. And if you document and you find out that you're being underpaid, that is your first recourse. Complain to DOL, get their help, and DOL will be more than happy to help because they're not only helping you, they're helping this entire US labor market as a whole when they investigate shoddy employers who try to underpay their workers. So the bottom line is know your rights, document properly, and use the right department. You have recourse, make sure you use your rights. And by doing so, it'll ensure that employers are not only paying you the fair wage, it'll also help other people who are trying to defraud their employees. They will try to be careful, and as a whole, everybody will be in a good shape.
Absolutely. And it's always best to have good knowledge about it. So research is very, very important. And thank you so much for the detailed answer, Chand. That was really nice. And at this moment, I would take this chance to say a big hello to all viewers out there who have joined us and have already asked their questions. I would say, please stay with us. We are definitely going to take up all of your questions. Hi to Dheeraj Reddy. And then we have Monali Thakur. We have questions already from Krishna Manohar, Ashwin, Ansa. Thank you so much for joining us. We are going to take them up. Just stay with us. For now, Chand, I have another question, and this is also another one regarding wage issues itself. So, what are the legal consequences for employers who fail to pay the required wages to H1B workers?
Sure. So a lot of times employers they don't pay the required wages, and the big thing is they just expect their employees not to complain. And unfortunately, a lot of employees, because they're non-immigrant workers, they're on non-immigrant visas, they don't want to fight the employer. And what that means is they're just keeping quiet. They're just being silent, and which is why I think people should understand that the law gives them a lot of rights. There are a lot of avenues available. If the employer is not paying the required wage, one does not have to be silent. There are avenues, and employer is going to face very severe legal consequences. And normally, what happens is the back pay. If employers have not paid as per the rules, they have underpaid, and if the employee complains, employers will be required to back pay the wages to the affected H1B workers, and that will be the difference between what was paid and the required prevailing wage. So the back pay, the back pay is something that's definitely going to happen if anybody has underpaid, and definitely, uh, that is something what would help you in case you find out that your employer is not paying you like they should. The next big thing is not just the back pay, but the fines and penalties. If they underpay you, it is not DOL is not just going to go back and say just pay the difference. Depending on the scenario, depending on the situation, depending on what exactly has happened, there are fines and penalties. DOL routinely imposes civil monetary penalties on employers for various wage violations, and the way these fines are imposed are it's based on the nature of the violation. What kind of a violation is it? Is it an accidental violation? Is it intentional? Is there a real good reason for that underpayment, and so on? So depending on it, if it's a systematic violation, systematic pattern in that company, sometimes there are huge penalties. So there is a very good help that we get from DOL, where DOL will impose civil monetary penalties for wage violations. And the next big thing is disqualification from future sponsorship. A lot of companies that hire H1B employees, a lot of them are H1B dependent. And what that means is without H1Bs, the companies cannot even function because they're dependent on H1B employees. And if DOL finds wage violations, severe wage violations, they might even be disqualified from sponsoring H1B petitions. So what that means is if somebody is on H1B, when they file for an extension, they might not even be able to file for an extension. They might not even be able to file for new employees, new H1Bs, transfers, etc. So their entire ability to hire foreign workers is limited. So disqualification from future H1B sponsorship, it's a big tool that DOL definitely can use if employers are found in violation of proper wage payments. And the next one is legal action. So we've been talking about DOL taking action. Also, the affected employee can actually go to the court and pursue an independent legal action. And this employee can go and ask for damages. They can ask for breach of contract, can ask for wage theft damages, and legal fees, and so on. So legal action independently in a district court or a local court of right jurisdiction, that's also a very valid choice that many people have, and that's something what people choose to use. DOL helps, but again, independently also you can take legal action. And the further thing is investigation and audits. Non-compliance definitely will trigger an audit by DOL. So if you are complaining to DOL, multiple people are complaining to DOL about the same company, typically we see audits being triggered. DOL will audit the company, will not only scrutinize one single underpayment of wage, but sometimes they scrutinize the entire company. They'll ask for the entire payroll records, entire records of LCAs filed by that company, proof of payment, and so many other things. So if somebody has a DOL audit, DOL investigation, it's not, sometimes it is not just one person they're looking at. They're looking at the entire company, entire employee list, entire payroll. Why? If if somebody complains, the company is going to be in serious trouble. Which the bottom line is, the companies have to be cautious. The companies have to make sure they're complying. They're always paying the wages on time. If not, DOL investigation, DOL audit is not a simple thing. It's a very complex and a time-taking process. And the final thing is reputational damage. if somebody violates wage laws, if even one employee is underpaid, that employee is not going to sit quiet. We expect the employee to go and to other employees, and it is the reputation. It is the reputation that gets them new talent, new employees. So once there is a reputational damage because the company is having a DOL audit, a USCIS audit, a DOL penalty, etc., nobody wants to join that company. So if a company underpays and has this reputational damage, tomorrow they can't even attract any talent. And the summary is employers definitely look at all these consequences, ensure compliance. So the simple thing to do is ensure compliance with the wage, ensure compliance with the LCAs, and doing so, you don't have to worry about all these consequences.
Absolutely. So, thank you so much, Chand, for making it so clear and for the detailed explanation. With that, I think we have covered some of the wage issues that come across during H1B. So I think we should take up some of our questions from our audience. They have been waiting for us. Hi, Dheeraj Reddy. Let's take up your question. I hope you're there. If you're there, please say hi back again, maybe. And his question is, I have a doubt regarding my H1B. My H1B is effective from October 1st. And if I don't want the H1B and want to work back on OPT status, how do I do that?
So when a H1B is approved, it gets approved in two ways. One, consular processing. The second one is change of status. The first thing you should see is look at your H1B approval copy. See if you have an I-94 at the bottom, and see if it has language like change of status has been approved. If you have change of status approved, the problem is before October 1st, you have to request a withdrawal, and you have to tell your let your school know that your H1B is withdrawn, show them proof, and doing so you
Mhm.
can maintain OPT status. So the problem is it has to be done before October 1st or before the date of your H1B validity period. So if you do it before your H1B starts, even after your H1B gets approved, you can maintain your F1 status. But in your case, right now, it is October 10th. So if you're past October 1st, your case has already been approved, you've already been granted change of status. What it means is your service probably already got terminated effective October 1st. Now, because the service got terminated, they will not let you get back onto F1 directly. Okay, so now the process is a little bit complex. You have to go out of the country and you have to come back. But because your H1B got approved with change of status, you cannot even get back onto OPT status. Your EAD is gone. Okay, so the bottom line is look at your H1B approval copy. If you have change of status and it says change of status effective October 1st, now is too late. But if you have done it before October 1st, you could have done it even after the H1B approval. If the company sent a withdrawal notice and you showed that withdrawal notice to the school, they could have saved your OPT. But now I think it is too late. Unfortunately, we have crossed October 1st. If your H1B approval says change of status has been approved, then effective October 1st, you are on H1B and there is no way to get back onto OPT.
Okay, so that is a little complicated, Dheeraj, but I hope you figure out. Thank you so much, Chand, for telling Dheeraj what to do. All the best, Dheeraj. And now let's go to Ansa. Ansa's question. I won the H1B, which was effective October. Can I apply for H4 and EAD for my husband to work in the US? I am on oh, sorry. I won the H1B, which was effective October. Okay, that's the one only. Oh, that's many times. Thank you so much, Ansa. And yes, here's the answer from Chan.
Sure. So looks like you have an H1B approval from October. Okay. So now that you have an H1B approval, definitely you can apply for H4. So H4 is just a legal status for your husband to stay with you. So you can definitely apply for the H4 now that you have H1B. Now the second part is EAD. So you can only apply for EAD along with H4 if you also have an I-140 approval. If you have an I-140 approval, yes, you can apply for H4 and also EAD. If you do not
Mhm.
have an I-140, you can apply for H4, but not really EAD. So EAD, H4 EAD can only be applied once you have a valid I-140 approval. And if you do not have that approval, you probably will have to start working with your employer. Ask them to sponsor your green card process and try to get your I-140 approved as quickly as possible. The minute I-140 is approved, you should be good to apply for EAD for your spouse.
All right, there you go, Ansa. Thank you for your question. Thank you for participating, and thank you, Chand. Let's take up this next question now. This is from Satish. I am on H1B and my employer didn't run pay slips for last 4 months, and I moved back to India. Now I'm planning to come back to US on H4 visa. Should I request my employer to run those pay slips?
Sure. So again, I think looks like some kind of a violation has happened with his prior employer. So there is no like running pay slips. I mean, if a company has filed a H1, they're supposed to pay. You cannot be benched. Benching is illegal. So if a company says, "Hey, there's no project, I'm putting you on the bench," the company is doing something illegal. So there is benching is not possible. That being said, right now you have a H4 visa. If you're coming back to US on H4, they're not going to ask you for your proof of employment when you're coming back on H4 because you're coming back as a dependent spouse. So they will ask you for the pay statements of your H1B spouse. So that is important. Your old pay slips are not important. So at least right now you should be able to come back into the country, and it's not about showing proof of payment. That being said, the company is supposed to pay you. So once you're back, maybe check back with the company and say, hey, you cannot be benched and you're supposed to be paid, and try to make them pay you. But right now, if the question is just coming back to US, at the port of entry, will they ask you for your pay stubs? More than likely, they will not. And if they do ask you, just be honest and tell the CBP officer that your employer did not pay you. Okay, because the employer will be in trouble if if CBP or USCIS or the consulate or DOL they find out. Definitely they will audit the employer. So if CBP officer asks you that specific question, you can be honest and say the employer has not paid you. That being said, even without the pay slips, because you have a valid H4 visa, you should be able to come into the country, and they will not cause you a problem because you didn't have the pay slips at the time of coming into the country.
That's interesting. Satish, thank you for your question, and thank you so much, Chand, for the detailed explanation. Moving on, we have Krishna Manohar. Hi, Krishna. And he's asking, what would be minimum wages for 16 plus years software engineer? Will lower wage make issue for visa process?
Sure. So when somebody applies for a H1, I think in the first part of our discussion we talked about LCA, the labor condition application that talks about the prevailing wage. So whenever a company is going to apply for a H1B, they have to apply for this LCA, labor condition application, and labor condition application. And as a part of this LCA, they're supposed to determine the prevailing wage. And the way that prevailing wage is determined is based on the position requirement. So we have to talk about what is that position, what are the job duties, and what is the location and the work experience requirements for this job. So in your case, you might have 16 years of experience. So you are highly qualified, definitely. But the wage is not based on your qualifications. It is based on what the position requires. So if the position is a junior level position, less than 1 year of experience is required for the job, the wages will be low. If it is a mid-career position, probably the wages will be around level 2 or level 3 based on the number of years required for the job. If it is a very very senior level role, okay, so you might be a very senior person, but we have to also look at the role. What kind of a role is the role? So if the role is a very senior role, you have to go with the highest wage level, which is wage level 4. So as a part of applying for the H1B, in your case, the company will do this analysis. What kind of a role is it? Is it a junior role, a mid-career role, or is it a very high level, highly senior level role? And accordingly, they have to select the wage level. So the exact amount of the wage, it depends on your work location. For example, if it is California software developer, it's definitely going to be in six figures. It's going to be a lot over $100,000 per year. If it is, for example, Oklahoma, the startup salary, the starting salary for a software developer is going to be a lot less than what's out there in California. So this kind of analysis is what happens when they file for the H1B, and a lot of times, you as an employee, you might be highly qualified, but the position might not require that kind of experience. So that is why sometimes you might see a lower wage, even though you are highly qualified. But again, if the position does require 16 years of experience, it will be the highest salary, which will be the wage level 4. So it will be at the wage level 4. So whatever is the highest wage for that particular occupation in that particular metropolitan area, that would be the wage the company will have to pay you. And this is all a part of the LCA, which is why it is very, very important that everybody that has an H1B filed, they should get a copy of the LCA. And what the law says is, the law says that the company has to release the copy of LCA to you. And that is why the employers cannot hide the copy of LCA. Every company has to release the copy of LCA to you. So that way you know what position you have been applied for, what kind of a requirement the position has, and so on. So definitely get a copy of your LCA from your employer, and that LCA will give you a lot of information that you want about the wages for your particular position.
All right. Thank you, Krishna, for your question. And I remember you from yesterday. Thank you for joining us once again. If you have more questions, you can keep commenting. Now we have Ashwin. Ashwin is asking, I'm concerned about potential issues with my H1B visa. My employer recently received a notice from USCIS regarding discrepancies in my initial petition, and I'm worried about the consequences. Can you clarify differences between H1B revocation and denial, specifically in my situation? Initial H1B approval in 2022. Employer received notice of potential revocation due to LCA discrepancies.
Sure. So again, this is another big reason why I think I wanted to talk about this topic this week. Reason is sometimes, like in this case, clearly the employee has not done anything wrong. He has been doing what he's supposed to do. He's doing his job. But USCIS came back and said there is some LCA discrepancy, and what that probably means is either he's getting paid less, or the company is not following what's in the LCA. And unfortunately, even if the employee has not done anything wrong, sometimes the employee gets penalized because the employer has not done things right, which is what have been seeing a lot lately. And it is very important that people have to be educated. They have to keep a copy of their LCA at all times, because they need to know that they're following the rules. If the company is not following the rules as per the LCA, tomorrow USCIS will definitely cause an issue, not only for the employer but also the employee. And I'll tell you the way they do it. And in this question, you specifically talked about revocation and denial, and also the fact that employer received a notice. So this notice is called a notice of intent to revoke, more than likely. So it is called a NOIR, notice of intent to revoke. So what they're saying is, we approved your H1B in the past because your H1B approval happened in 2022. Now the law says that USCIS cannot randomly revoke a H1B. Before they can revoke a H1B, they're supposed to give a notice to the employer, and that is that NOIR, notice of intent to revoke. And this notice should lay out all the issues that USCIS think is a problem. And then they have to give 33 days on top of that notice. So basically, what is happening is, before USCIS can make any decision, they are letting the employer know that they found all these issues. They're giving him time, a 33-day time to respond back. And I've had many cases where sometimes USCIS got it wrong. So you're able to respond back to USCIS, and we were able to get a reaffirmation. So we had a lot of cases where USCIS pointed out a mistake. We answered, we were able to show that the company is doing everything right. If that is the case, we get a reaffirmation. We also had cases where the company was not able to prove that they've done everything right. So in those kind of cases, we were not able to go back to USCIS and show with clear proof that everything is right. In that case, USCIS will simply revoke the H1B approval. So what that means is, if the employer is able to answer back and counter the allegations, you will definitely get a reaffirmation. Nothing will happen. But if the employer is not able to counter their allegations, USCIS's allegations, tomorrow you have a potential revocation. And since you said it is initial H1B, the initial H1B gets revoked due to fraud. Tomorrow you're not even cap exempt. You have to go through the lottery once again. So that risk is there. So the minute I hear that somebody's got a notice of intent to revoke their initial H1B approval, it means there is a big risk, and the company has to fight very, very hard. And normally, also depending on what kind of a notice it is, what kind of an allegation it is, if it looks like the company is doing something wrong, I would also advise you to to look for another employer and transfer your H1B if possible. Problem is, transfer is not always guaranteed. If the employer has done something wrong, has misrepresented some facts, tomorrow you might have a problem with transfer. So transfer is not always guaranteed, but again, if USCIS is making some allegation, there is some issue, definitely time to look for a new employer if the employer is not able to fight it. And sometimes the employer might be able to fight it. Okay, so noir is definitely a cause of concern, and the employer has to answer it as quickly as possible because they don't have much time. They only have 33 days. My guess is your employer is already in the process of answering it, and I just hope it is not anything to do with multiple registration, because if it is to do with multiple registration and there is really merit in what USCIS is saying, I've seen a lot of those cases get revoked. So it all depends on what exactly was given in that notice, and check with your employer. Make sure the employer is responding accurately. Ask them to disclose information, because if it is something that they cannot fight, you have to look for options. Okay, so just work with your employer to figure out what exactly is in that notice. Knowing the content of the notice is very important for you to plan your career.
Absolutely. And thank you so much, Ashwin. All the best. I know you are going to do it. So thank you so much, Chance, for taking it up and showing Ashwin what can he be, how can he go about from here on. And Dheeraj Reddy is back. He's saying, I'm there. So thank you, Dheeraj. And he has follow-up questions. So let's take them up. Um, how many months of pay slips is required to H1B transfer from current company to another company? I got job in another company and would like to move to that company. But my H1B is effective from October 1st. So will it be possible to transfer to another company without any pay stub from current company?
Sure. So USCIS has no restriction on the amount of time that one has to wait. If you want to transfer right now, your approval is valid from October 1st. If you want to transfer right now, you should be able to do it. In our law firm, we already have a couple of cases where people are looking for transfer after October 1st. So there is no requirement that you are supposed to have two pay statements. However, there is a very important requirement that on the day of filing your H1B transfer, you have to be in a valid status. So today, if you're filing, if your new company is filing a transfer, the new company does have the burden to show that on the day of filing. So, for example, today, October 10th, you have maintained valid H1B status from October 1st to October 10th. You might not have received a pay stub because October just started, but they still require you to show that you have maintained valid status. And if you have maintained valid status, the new company should be able to file a transfer for you. And I do see every year, I do see a lot of employees transferring their employers. Even before they get one pay stub or two pay stub, because sometimes they get a very good offer and they have been working with this company for last 1 2 years, but now all of a sudden they got a new job offer, which is a very good attractive offer. So some employers fraudulently tell people that, oh, you have to wait for two pay stubs, you have to wait for 2 months. No, that is not true. You can transfer right now if you want. There is no requirement from USCIS that you have to wait certain amount of time before doing a transfer.
Okay. All right. Thank you so much, Chand, for taking that up. And Dheeraj, I hope you've got your answers. Thank you for your questions. And I think we should quickly take a short break now, Chand, and then we'll be back with more questions if that's fine. So, folks
Sure.
out there, keep commenting, and we will take up your questions. And don't go anywhere because we've got to speak more about H1B and wage issues, LCA problems, and even fees sometimes. So, yes, don't go anywhere. We'll talk more on Immigration and Jobs Talk Show with none other than Attorney Chand Parvathaneni. And in case you want to have a one-on-one consultation and maybe you want to discuss your case further with Attorney Chand, why not call him up on this number? 817-523-8247. Please note it down. It's there on the screen. And you can even email him law@spblawfirm.com and go visit www.spblawfirm.com to get to know more about Attorney Chand Parvathaneni and their law firm. Don't go anywhere. Let's take a short break. Hello, everyone. Welcome back to Immigration and Jobs Talk Show. And this is a very interesting webinar we're having today with attorney Chand Parvathaneni, all the way from Dallas, Texas, from SPB Law Firm. Thank you so much, Chand. It's been a great webinar so far. We've been answering so many questions for us, and we are discussing today if your is your H1B at risk? And we are talking about wage violations. We already took up some questions and also about LCA problems. And thank you so much, all you folks out there, for participating. Dheeraj Reddy says, thank you so much, Chand. So thank you once again. Well, Chand, we also have questions for you from these Facebook pages I was going through, and I think we should just take them up in our groups. So, all right, then. This first one on the screen is hi, this is from Anna Gracia. Hi, I don't know much about EB2, but my husband's work is applying for his green card with this process. What are the chances to get his approval? What happens if it's denied? He has H1B um, work visa. What I know is that they are preparing two letters for his actual boss and former, and they will send these letters, but that's it. We don't want to worry, so I'm looking for experiences. Thanks.
Sure. Um, so I think what I understand is I think the employer is applying for the EB2 process, and EB2 process is basically one of the green card processes. So they have multiple categories: EB1, EB2, EB3, EB4, EB5. So EB2 category is for green card where somebody has at least 5 years of experience after bachelor's degree or has a master's degree. And when we talk about the chances of approval, so the company has a very, very big, complex process to follow. They have to apply for a prevailing wage. They have to advertise. They have to advertise in a certain format in a newspaper, 2 Sundays in a newspaper, and the state work order. There's a lot of things that they have to follow. And once that is done, if they don't find any US worker, they go and do a filing called perm filing with DOL. And once the DOL filing is done, it takes about a year. So this entire process is almost a 1.5 to 2 year process. So if the company is doing everything right, in about 1.5 year, 1.5 to 2 years, they should have their I-140 approved under EB2 process. And as a part of this process, what the company will do is the company will highlight the work experience of the employee, the educational part of the employee, and so on. So the part where you mentioned about they're doing the previous experience letters and so on, the experience letters are typically an integral part of EB2 process. And I think looks like that is what they're doing. They're preparing the file. They're getting the things ready. They're getting the advertising ready. They're getting his qualifications ready, and so on. And if everything is good, the EB2 will get approved. The EB2 I-140. And for some reason, if it is denied, it is not going to impact the H1B visa. So the H1B visa is for non-immigrant work. The EB2 that they're doing, that is more for him to get his green card. So if he is able to prove his work experience, he's able to prove his credentials, typically the EB2 should get approved. And once the EB2 gets the I-140 for EB2 category gets approved, they're just waiting for the date to be current and then apply for the green card. So most of the time, because people are highly qualified, typically the denials are pretty low, and work experience letters are very, very important. And if the work experience letters are very clear, they're able to prove that he has the right experience. Most of the time, the filing should be good, assuming the company is doing everything by the book, following the recruitment requirements, recruitment guidelines, the cooling off period guidelines. If the company does everything right, the perm should be approved, then the I-140 should be approved. And then at that point of time, they're just waiting for the dates to be current before they file for the green card. So I would not worry much. Just document your qualifications, provide it to the company, and everything is company's responsibility when it comes to the green card process. The perm is their responsibility. The advertising is their responsibility. The I-140 is their responsibility. So if that is approved, the 485, when the dates become current, that will be the employee's responsibility. But up to the I-140 stage, typically the companies will handle it. And I would not worry much about it. Let the company do their work, provide all the experience letters to the company, because that is very critical to the approval.
All right. Thank you so much, Chand, for taking that up. And Anna, yes, I hope you've got your answer. Well, I got more, but I think we should quickly take up one from Heavenly Insight World who just commented on YouTube. So let's take that up.
Hmm?
October 4th, 2024, 214 214D was denied during my F1 visa interview. So again in November 2024, what are the critical things you should prove are required to pass the interview? He has a bachelor's degree and he is from Ethiopia.
Okay. So, if you're going for an F1 stamping again, it's always boils down to two important things. One, your ties to the country. Okay, so if you're from Ethiopia, the first and the foremost thing they're going to see is, are you going to come back to Ethiopia or not? And what that means is, are you an intending immigrant in US or not? Intending immigrant means you come to US, you intend to stay back in US, you don't want to go back to your home country. So that is one thing that they will always check for. Okay, so are you an intending immigrant or not? What kind of ties you have to Ethiopia? Why would you come back to Ethiopia? That is one very important thing. The second thing they're going to look for is, are you really coming to study? Do you have the resources? Or are you coming to just come into US and then do a part-time job and make money? So that is something what they will do. How do they check for these two? So the first thing is ties back to Ethiopia. So what they're trying to see is, do you have family in Ethiopia? Do you have a property in Ethiopia? So what kind of ties you have to Ethiopia? What is it that makes it strong for you to come back to Ethiopia? Okay. So normally
Mhm.
what people do is they show your financials, what kind of properties you have in Ethiopia, what kind of family ties you have in Ethiopia, why you don't really need to stay back in US. Why will you come back to Ethiopia? That is one thing that is very important. The second thing is the school. So, what kind of a school you're going to study in US, and are you really going to complete that program? And is there a chance that you might do some part-time jobs and not really follow the F1 regulations? So they'll have questions surrounding that. So you do have to convince them on why exactly you have chosen this university, why exactly you have chosen this course of study. Convince the officer. And what that means is, from your background, you have to talk and explain what your long-term career goals are, how you would complete this course, and how when you come back to Ethiopia it's going to help you. Okay, so you have to kind of tie these together. And normally, if you have strong financial ties back with Ethiopia, and you have resources to pay for your tuition, and the officer feels that you don't really have many ties to US, which means that you'll go back to Ethiopia. And from your profile, if they feel that you are going to study and continue your education and you're going to complete your courses, and you will go back, if they feel that way, they normally issue the visa. And nowadays what we see is, most of the F1 visas, they're being a little bit lenient, as long as you're able to demonstrate these two things: ties back to Ethiopia, and prove that you really want to come back to Ethiopia and you can complete the course. You have enough resources, enough money. Because sometimes I've seen cases where the person is really qualified, they want to really study, but they don't have enough financial resources. So the officer feels that they're going to go and do a part-time job, not comply with the rules of F1. So your financial strength is definitely going to make a big impact. Take all documentation about your finances. Sometimes parents will give affidavits. Okay, sometimes your parents who own properties, they will give affidavit. They will show evidences of their properties to show that you have very very strong ties to your home country, you have family, you have properties, and all those things. Okay, so the more because everybody's fact pattern is different, more you're able to show your properties and family members in Ethiopia, the more stronger your case will be.
All right. Thank you so much, Chant, for taking that up for Heavenly. And I really hope you've got your answer. If you need more clarifications, please keep commenting. And Chand, I have more questions for you from our Facebook group, so we should take them up. And this time it is this next one. This is firm applied on June 9th, 2023. It's been 487 days, 15 months, 29 days only waiting. That's what it's saying.
Yeah. So, so most of our June cases, they started coming in the last week of June 2024 and July. So, so 13 months is what I think typically one can expect. So since you mentioned June 9th, 2023, at least in our law firm, we had a lot of cases from June. We saw adjudications in the month of last week of June, and most of our June cases came in the month of July. And now it is October. So to me, it looks like it is probably not normal. Probably you're one of those rare cases. Uh, and to me, what it means is more than likely the company is probably going to get an audit because June cases, now it is October. The case is still pending. Maybe DOL is doing some additional checks. Maybe they're about to issue an audit. So audit is a big possibility. That being said, 12 to 13 months is normal, and you're about 2 months, probably 2 to 3 months more than what other people are seeing. So I would say that at least you're not in the normal timeline. And but again, 2 3 months here and there is probably possible. So even though most of the cases started coming in July, 2 3 months difference might always be there. But my guess is definitely in the next 2 to 3 weeks, if you don't hear anything, I would be concerned, and more than likely the company is going to get an audit. What you can do is just check back with the company just to make sure that this case has not been adjudicated. Just have them check in the flag system to see if it is really waiting or if there has been any audit issued or anything.
All right. So there we go. We have answered Manikandan's question on Facebook group. Thank you so much, Chand, for taking that up. I have another one,
Sure.
and this is here. This is from Anurag Samantha. Can I file H4 EAD after getting H1 extension and H4 extension receipt number, or I have to wait for approval? Please suggest.
No, you don't have to wait for the approval. So if you have an H1B extension receipt and an H4 extension receipt, make sure you submit it along with your EAD application, the 765 application. So that way they can tag the H4, because the H4 has to be approved before they approve the H4 EAD. But while it is still pending, you can still apply for H4 EAD. The only thing is they will not approve H4 EAD until your H1B, your spouse's H1B and your H4 is approved. But you definitely can apply. So go ahead and apply. So that way, by the time in the next couple of months, your spouse's H1 will get approved, your H4 will get approved, and down the line, the H4 EAD also can be approved. So definitely, you can go ahead and apply. Only thing is, they will not take a decision until the H4 is approved.
Okay. But thank you so much, Chand, for taking that up for Anurag, and I hope that this is going to help Anurag. Thank you. I have more
Yep.
questions, so we'll take that up as well. This is an anonymous member asking, hello, has anyone with an H1B visa gone through the process of changing their status from uh, changing their status to B1, B2? I'd like to know if this can be done personally or if an attorney is required. Please comment your opinions and we'll ping you if additional information is needed. Thanks in advance.
So the H1B to B1 B2 conversion is like a very straightforward process. It is pretty easy, and most of the calls when people ask us to file for B1 B2, we also suggest, hey, you can do it by yourself. And I always advise that it is not a complex process. If you're comfortable, do it by yourself. And only those cases that people are not comfortable, we do it. And we do it in our law firm, but I always tell them it is so easy, and I always tell them to do it directly. And a lot of people have done it. I don't think it's a very complex process. The beauty is you can just go online. You can do this form I-539 online. So if somebody wants to do it online by themselves, go search for this form I-539. It's available online at USA's website, and you should be able to change your status from H1B to B1B2 by properly filling up that online form and going through the
Oh,
process.
that's really nice. Thank you so much for taking that up, Chand. And let's move on. I have another one. This one says, "Hi." This is also an anonymous member. My wife recently converted to H1B from H4, and she had an H1B Dropbox slot last week, and status got updated to refused. How will embassy contact the applicant if they need any additional documentation or if they want applicant to visit in person interview? Will my wife passport stay with the embassy until the case is resolved. Heard that for many people, status getting updated to refused and then to approved. Is that also a possibility?
Sure. So, so this person has had a Dropbox with the embassy, and refused means it's temporarily refused. It is not a denial. And what is going to happen now is the consulate, the embassy, the DOS, they will be doing some background checks, and the background checks could be on the company, the background checks could be on the end client, the project, or maybe on the employee. And sometimes, if the background checks come quickly back, everything is good, they will issue the visa. And sometimes what they do is they send out like an email to the employer. They ask the employer to respond back to that email, and that also is very common. And if those verifications are done, they might approve the case. And sometimes what also could happen is they could ask them to come for an interview. So that also is a possibility. So what's going on right now is a background check is happening, and sometimes they don't require any input. Sometimes they require the input of the petitioner, the H1B employer, to validate a couple of things. So all these things could happen, and and sometimes they might be called for an interview. So all of these are a possibility. And I've seen cases where the case got approved once the background checks are done. So refused will change to approved. Sometimes they get called for an interview. So all of these things are possible in the next couple of days. And as far as the passport is concerned, it will stay with the embassy. But sometimes, if somebody has a need to travel and they need to urgently get their passport back, they can contact the consulate, and they should be able to get their passport back. So there is a way. If you don't require the passport, let it stay with them, and they will finish their process. But if you require the passport, you can always contact the embassy and get it in case they're taking too long. And my guess is
Mhm.
more than likely the employer might be getting an email in the next 2 to 4 weeks. That's a possibility. Or if everything is good, they might even update the case to approval in the next couple of days. So everything we just talked about is a possibility.
All right. Thank you so much, Chance, for taking that up and for the detailed explanation, of course. It's been so far so good, very enlightening, learning so much today in this episode as well. Thank you, Chand. I have this next question, and this is also from an anonymous member asking, I received approval for my H1B visa on October 1st following the resolution of B221G issue. However, my spouse's H4 application was initially approved but later refused with an email stating it's under administrative processing. Is it normal?
Sometimes it is a possibility. I've seen that happen. And sometimes what they do is they actually, because looks like initially he got a 221G. So my hunch is the consulate probably thought his H1B is not approved, and they probably refused it. But I think it is in administrative processing. So they're doing some background checks. And eventually, my guess is they'll either approve the H4, or sometimes I've seen them come back and ask for some additional information. So they might come back and ask for some additional information. It's a possibility, but it's a temporary refusal. So what's going to happen is either it'll be approved in the next couple of days, or if the consulate has any other further questions, they'll probably contact the applicant and ask them to provide those details and issue the visa. If the 221G for H1B is approved, most of the time the H4 probably is like something small. H4 221Gs
Mhm.
get resolved pretty quickly.
Okay. Thank you so much, Chand, for taking that up. And I think we should take up Rick's question. He's asking, sorry, RK's question on YouTube. And the question is, if you got layoff on H1B and did a change of status to B2 asking for 6 months. Now the 6 months has passed. The B2 is still pending. Are you now out of status given that date you requested has passed? And what date will be on your B2 approval? Is it true that you can't file I-539 online with your spouse and child?
So two questions here. So the first part is the 6 months period. So if, because when you apply for B1 B2, you put an end date, you put the date until which you're requesting this change of status. And when the B1 B2 gets approved, typically that will be the end date. And if you cross that end date, what typically happens is in the future when you come back into US, sometimes they look at the approval and say you only had an approval until this date and you stayed back in the country after this date. and all of that is unauthorized stay. It could cause a problem. So we always say if you have 6 months of time, if you don't get an approval by the time, you should leave the country or at least file another application if you have a need to file for an extension. But if you don't do anything, you know that when you get an approval, that approval will only have the end date as per the date you requested in the 539. So bottom line is don't cross the 6 months period. You could run into a problem down the line. And the other part is when you have a child and a spouse and you're trying to file a B1 B2 online. Uh, Online you can only file one application at a time, so you have to do two applications, one for the spouse, one for the child, if you do it online. If you do it in paper, they have I-539 and then they have I-539A. So if you're asking for the same classification, from same classification to same classification, you can put your spouse and child in the same one single application, which is why people say if you have a child, just do it in paper, because you can only file a single application, single 539, and you'll attach a 539A supplement, and you only pay the fees one time. If you do it online, you can't do it that way, you have to do it separately. So which is why the preferred way is just do it online and do it in under the same application.
All right. There you go, RK. You have your answer. And thank you so much for your question. Thank you, Chand, for taking that up. Do you still have a couple more minutes, Chand, if you don't mind
Sure,
sticking
sure,
around
yeah,
for a while
let's
more?
finish the questions. Yeah, yeah.
Great, great. So I think we should take up this next one from the Facebook group. This is also an anonymous member. Hi all, can you stamp your H1B visa with latest extension validity while your current visa stamp valid for a few months? Or will it be a problem as visa consulate cancel your existing visa stamp and your stamped visa valid from new date? And there can be a problem with this as current visa might be cancelled by consulate. So, can you have two valid H1 petition stamping on passport? Or ideal scenario is to plan travel after current stamp expires? Thanks in advance.
Yeah. So no, no, you can still go ahead with your stamping. So you can go ahead with your stamping, and when you go for stamping, provide them the extension approval copy. So when they see the extension approval copy, what they will do is they will issue a visa with the expiry date that's matching your new extension approval. So you can travel right now, and if you have an extension, just when you go for stamping, show them that extension approval copy. So that way you will get a H1B stamp with the new extension. You don't really have to wait until the visa expires.
Okay. Thank you. Thank you, Chant, for taking that up. And this next one is from Rakesh. I heard that they are stopping in immigration while coming back to US. If they are staying more than 1 month in India, is it true or rumor? I am on H1B.
I mean, again, there might be one-off cases, because I do hear one-off cases where somebody is like stopped at the port of entry, and for various reasons they're sent back to their home country, and that is not
Mhm,
because they stayed for more than 1 month. There is more than that. So what happens is whenever somebody comes into US at the port of entry, they're asked a lot of questions. And if the officer suspects that something is wrong, and once they enter the country, they're going to be put on the bench, they might be
mhm,
sent back. So the reason is other reasons. Sometimes they find some violations. Because of that reason, they can be sent back, but not because somebody just took a leave or a vacation for a month. Just taking a vacation for
okay.
1 month, 2 months, it should not impact at all. We have a lot of cases where people take extended time off because they need to attend to some family matter. They stay for a long time
Mhm,
and they come back. That by itself will not cause any issue. The whole big thing they have to prove is the day they're entering into the country, do they have a valid
mhm,
project with their employer or not? Will they start working the very from immediately once they enter the country? And are they working as per the terms of the LCA? If all of that is true, they should not have any issue. They will not be stopped.
okay.
If they're stopped and sent back, it is for probably some other violation, not because they took some extended time off in India.
All right. Thank you so much. And that is the answer for Rakesh. Thank you so much for taking that up, Chand. And I think we will go with the last question for today. We have another comment on YouTube. This is from Sampath. Thank you so much for joining us. Sampath is asking, my friend received a notice of intent to revoke for an LCA violation due to a mismatch in address and place of work found during a USCIS site visit. They later filed an H1B amendment, which got approved. However, this notice is focused on revoking the previous extension and they only have 20 days to respond. What are the options available? And would changing employers and filing a new application help while simultaneously responding to the NOIR? Let me know if you need further adjustments.
So in this case, I think the good thing is looks like an amendment has been filed, and what I would do in this case is I would upgrade that amendment right away. So if that amendment is approved, he might be okay, because if the amendment is approved and they revoke the other petition because amendment was not timely filed, he is still probably going to be in valid status. The only thing is we don't want the H1B, the base petition, to be revoked due to fraud. If there is no fraud, but just a late filing of an amendment, more than likely he might be okay. But what he should do is, rather than look for a transfer, if that is the only reason, ask the amendment to be upgraded by your employer. So if the amendment gets upgraded, if the amendment gets approved, then you're good. Even if the other petition gets revoked, your amendment is approved and you should be good. Okay, so the thing is, I think in your case, because the amendment has been filed, more than likely you might be able to get an approval for your amendment, and then you should be okay. So, two things. One, the employer should respond to the NOIR in 20 days. You still have 20 days. But then the other option is just immediately file for an upgrade of your amendment petition. And if that amendment petition, because it's only a 15-day process for premium processing. And if your amendment is approved in the next 20 days, then you're absolutely good. Okay, so with that amendment approval, because the revocation, the NOIR is only for the other petition, not for the amendment. So if you get an approval with an amendment, I mean, I think you should be okay. And that is what I think I would focus on in your case. That being said, also the NOIR has to be responded. So just make sure the employer responds to the NOIR. But as a backup, if the NOIR for some reason is not successful, if the amendment gets approved, you'll definitely have a good backup.
All right. Thank you so much, Chand, for taking that up. And Sampath, I really hope you got your answer. Thank you for participating
I
and for your
think
question.
I think he's put another comment. He said the amendment is already
Oh,
approved
yes.
already.
Yes.
Yeah, if that is the case, is that you have a good backup. You don't have to worry, because your amendment is approved. So unless they come back and revoke your amendment and send a notice to revoke your amendment, your status is good. So technically, if the amendment is approved, you should be fine.
All right. There you go. I think we have completed it. And thank you so much, Sam. I hope you have more clarified answer now. And all the best. Thank you so much, Chand. It was really great to have you with us, and thank you so much for participating and so patiently taking up each of our questions. I had so much more to discuss about this, but I think that's a wrap for today's webinar. I mean, a real big thank you to Attorney Chand Parvathaneni for sharing your invaluable insights. And thank you all for joining us across YouTube, Facebook, LinkedIn. And thank you so much, Chand. Do you have any end notes to wrap up today's discussion?
Sure. So I think one thing that everybody should leave this today is you should get a copy of your LCA. Everybody should look at their LCA, because if the employer accidentally is making a mistake, you need to point it out to the employer, because sometimes if the employer makes a mistake, you'll be penalized. So always look at your LCA. Make sure you're getting paid. You're working as per the terms of the LCA. You don't want any surprises, like getting a NOIR, a notice of intent to revoke or anything. So everybody should demand the copy of the LCA from their employer, and if the employer does not give them a copy of the LCA, you can actually complain to DOL. Okay, so it is not an option. Employers have to give a copy of the LCA. So make sure everybody has their LCA and you're following everything as per the terms of the LCA.
Absolutely. In fact, I really had some more questions about LCA. And if you don't mind, Chance, maybe we could continue with this topic in the coming week. If
Yes.
you can
Yeah.
join us again, it'll be great.
Yeah. Yeah. Sure, Nipasa.
Yeah. All right. Thank you so much, Chand. It was really great having you and such an honor and a pleasure always. Very insightful webinar. And folks out there, if you want to consult Attorney Chand Parvathaneni, why not call him in this number 817-523-8247. That's his number. And you can email him. His email address is law@spblawfirm.com, and go visit www.spblawfirm.com to get to know more about attorney Chand Parvathaneni. Thank you, Chand, once again. You have a great day, and I'll see you again next week.
Thank you, Nipasa. Bye bye.
All right, thank you. And folks out there, if you found this discussion helpful, make sure to like, share, and subscribe, especially folks out there who got all of your answers today. Maybe if you're watching us and even after the stream has ended, please comment that you've got your answer. It would really be helpful to know. And also subscribe to Immigration and Jobs Talk Show for more expert advice and updates. And absolutely stay informed, stay empowered, and I will see you next time. In case you want to contact me and you have further questions, call me on this number or WhatsApp me on 408 335 6444, and you can email me. My email address is nipa@staffingly.com, and go visit us on www.staffingly.com. Thank you, and y'all out there have a great day ahead. This is Nipasa signing off from Immigration and Jobs Talk Show.